Hello everyone, welcome to this evening's lecture. I'm Alice Thompson, Student Manager at the Inn. Before we start, I'm going to briefly run through some arrangements for this evening's session. Our speaker is going to talk for about an hour. Please direct all questions using the Q&A function so that the speaker and I can manage your questions clearly. Please only ask questions that relate to the topic of the lecture. I will stay on for 5 minutes or so at the end to answer any general questions you might have. If you are having problems with your connection or other issues, you can let us know in the chat function. If you do drop out of the meeting due to internet issues, please sign back in as soon as possible using the same details. Once the lecture is finished, you're free to leave. We will record your attendance using Zoom's built-in recording, which lists the attendees, including when you joined and left the session. The accreditation of the session on your record is not an automated process, and the reports have to be checked and the qualifying sessions credited manually on your record. So please bear with us while we get this done, and it can take a week or less for this to appear on your record. Tonight's lecture is on the regulation of barristers past, present and future, and our speaker this evening is Professor Stephen Mayson, Independent Non-Executive Chair, Director and Advisor. Thank you, and I'll hand over to you, Stephen.
Thank you very much, Alice. I'm just going to hopefully share my screen and get the slides up. And we don't want to start there. Great. Hopefully you can now all see the slides that I'm going to use. Thanks very much for joining on such a hot, sticky evening. Legal services regulation isn't generally known for its jokes or funny moments, but I'll do my best to keep it as light as possible. My purpose this evening is to take you on a brief journey through the history of the regulation of barristers. But I want to concentrate more on the current setup and spend most of my time looking at where the flaws in that setup are, to give you a sense of why there are likely to be future changes in regulation that will or may affect you. The structure of the lecture is not terribly imaginative. Following an introduction, I'll talk about the past, the present, and the future. But as I say, most of the emphasis will be on present and future. So we're fortunate in Lincoln's Inn to have our black books as the longest continuous records of its members and affairs of any of the Inns of Court. As we celebrate this year, the black books date from 1422. The earliest record provides a list of 96 men, yes, they are men, who were members of the Inn before 1420. So the profession of barrister has a long history. Holdsworth, in his multi-volume work, A History of English Law, writes that it's difficult to say whether there was ever a time when citizens were not allowed assistance from their friends when appearing before a court. The right was certainly available as early as the reign of Henry I, 1100 to 1135. And a profession of pleaders had undoubtedly emerged in the King's courts by the middle of the 13th century. They're referred to as early as 1235. The notion of a legal profession appears to have emerged during the reign of Edward I, who reigned from 1272 to 1307. At this time, there were already two distinct types of lawyer, the early forerunners of barristers and solicitors. There were those known as sergeants, who would act as pleaders, appearing in court and speaking for their clients. There were those known as attorneys, who were also present in court, but were there to handle procedural matters and manage their clients' litigation. Although initially both types, sergeants and attorneys, were unqualified amateurs, those who through frequent appearances developed recognised expertise became sought after legal representatives. Even in the 13th century, it would seem that an increase in both the volume and complexity of litigation were contributing factors. Then it appears that by the late 13th century, those who specialized in pleading became subdivided into sergeants as the senior advocates, rather like today's QCs, and apprentices, who, despite the title, were practicing law and representing clients in their own right. It is these apprentices who are the predecessors of barristers, though it's possible that they might have started out as attorneys. And indeed, attorneys were initially members of the Inns of Court, although later excluded from the Inns. So let's look at some of the earlier history, from the early days to the 13th century. It's tempting to think of regulation as a recent phenomenon, but regulation takes many forms, and it's often incidental to other developments. So although originally litigants would have been expected to appear in person, by medieval times a practice had already developed, under which litigants were allowed to bring someone into court to counsel them. This gradually evolved into royal or judicial permission, and later authorization, for individuals to practice before the courts. And from this, judges used their inherent powers to fine lawyers for poor pleading and other misconduct, early professional discipline. These early developments were facilitated by statute as early as 1275, and clearly laid the foundations for elements of the regulation of lawyers that we would recognise today. For example, the Statute of Westminster I in 1275 prohibited deceit or collusion by any pleader in the King's Court, and also addressed concerns about excessive litigation, with prohibitions on maintenance and champetty, as well as on abusive litigation tactics. Its novelty also included the ability to imprison lawyers as a remedy for misconduct. The Statute of 1275 was followed by other enactments in similar vein, including those addressing conflicts of interest and competence requirements, all of which seem to have assumed that limiting the number of lawyers would increase competence and conduct, an argument that's still used today. Indeed, an ordinance of Edward I in 1292, in recognising apprentices as a separate part of the emerging legal professions, might well have led to the creation of the Inns of Court. Although the 14th century was much quieter in regulatory terms than the 13th century, it would appear that certainly by the time of the Inns formation, professional sergeants, apprentices, and attorneys had achieved their monopoly on legal advice and representation. Also by then, much of what we now recognise as the regulatory requirements applying to practicing lawyers were already established. As one commentator has put it, all in all, the medieval regulation of lawyers created the foundations of modern regulation. Moving now from the Inns formation to Victorian times, we can see as a result of this early history, the distinction that we now have between barristers and other legal professions, and particularly solicitors, was firmly established. It was also clear that call to the bar and associated rights of audience originated from the judiciary rather than being derived from statute. This led Lord Mansfield to declare in Crown and Gray's Indentures in 1780 that the original institution of the Inns of Court nowhere precisely appears, but it is certain that all the power they have concerning the admission to the bar is delegated to them from the judges. As we know, the right of the Inns of Court to call to the bar continues to this day. However, the regulation and discipline of barristers has gradually been transferred from the Inns to the General Council of the Bar, formed in 1894, and then to the Bar Standards Board from 2006. Over time, though, rights of audience have been increasingly subject to statutory confirmation. I'll address the current position shortly, but let me draw this historical section to a close with a brief look at the position in the county courts. I've chosen an episode from the mid-1850s to take a shortcut through 500 years of history, as well as to illustrate the professional and social elitism then achieved by the bar. The County Courts Act of 1846, described as an act for the more easy recovery of small debts and demands in England, is the basis of the current county courts system. Section 91 allowed both barristers and attorneys to appear and was designed to dismantle the monopoly on appearing in the county courts then held by barristers. It was later viewed by some as having been a great boon to the public by removing technicalities in existing rights of audience. However, the Attorney General, Sir Alexander Cockburn, claimed that attorneys had been colluding to fix prices and monopolise work in the county courts by excluding the bar. He argued that this was to the detriment of the public and that the monopoly had merely been transferred from barristers to attorneys. Now, my reason for sharing this with you is not so much the statutory outcome, but rather the following extraordinary statement from 1851, attributed to the Attorney General by Hansard, as the matter was discussed in Parliament. The record records this: "The business of the advocate in all our courts, superior or inferior, should be conducted by men of trained education as advocates, of established position as gentlemen, as men of honour." He, the Attorney General, did not believe that anyone was visionary enough to imagine that it would be an advantage to dispense with the advocacy of a class of men who had enjoyed the highest education and who were known to be influenced by the highest feelings. If any monopoly at all were allowed to exist, it would surely be better to place it in the hands of a highly educated class of men, rather than in those of an inferior class. It's perhaps difficult to imagine such comments being made in the House of Commons today. Nevertheless, amendments to the 1846 Act were proposed, and despite more convincing opposing arguments, the Attorney General's view prevailed. A prohibition on the appearance of attorneys acting for other attorneys was included in the County Courts Act 1852, and the practice of solicitors instructing barristers to appear in county courts was thus fortified by the attorney's elitist advocacy. While the medieval period might have provided the foundations for regulation, and the Victorian era the high point in professional ascendancy, the 20th century marked a significant turning point in political and economic thinking about regulation, as well as in social attitudes towards professional elites. So we now move to the turn of the 21st century. Interestingly, we find that some of the same concerns of the medieval era are still with us. For instance, a feeling that there are too many lawyers, a sense that the quality of practitioners is not universally high and ethical, and a view that the behaviour of lawyers is not always as it should be. say in relation to abusive litigation and strategic lawsuits against public participation, also known as SLAPs. So in 2001, the Office of Fair Trading produced a report on competition in professions. It wasn't limited to the legal profession, it was more general. But it recommended that unjustified restrictions on competition should be removed. The government at the time responded with a consultation paper and a report into competition and regulation in the legal services market. That report concluded that the current framework is outdated, inflexible, overcomplex, and insufficiently accountable or transparent, and that a thorough and independent investigation is needed. There was also a lot of evidence that in the pursuit of professional self-regulation, as it was at that time, client complaints about lawyer performance and service were not being dealt with in a timely and effective way. To suggest that the regulatory functions were perceived to be discharged in a way that resulted in the legal professions appearing to look after their own would probably be to put it as dispassionately as one might. In July 2003, then, Sir David Clementi was appointed to carry out an independent review of the regulatory framework for legal services in England and Wales. He was an accountant by background, and at the time, chairman of the financial services giant, Prudential plc, and a deputy governor of the Bank of England. He later went on to become chairman of the BBC. Sir David reported in December 2004, 18 months later. And following a consultation paper from the then Department for Constitutional Affairs, now the Ministry of Justice, subtitled Putting Consumers First, Sir David's recommendations were broadly adopted in the Legal Services Act 2007, which forms the current framework for modern legal services regulation. The 2007 Act is large, at 450 pages, with 214 sections and 24 schedules. And it has a number of notable features. First, it defined barrister for the first time in statute as an individual who has been called to the bar by and in a court and is not disbarred. In doing this, the Act recognised the role and the right of the Inns in the conferment of professional title. Secondly, the Act sets out 8 statutory regulatory objectives for legal services regulation. These include protecting and promoting the public interest, supporting the constitutional principle of the rule of law, encouraging an independent and strong legal profession, and promoting and maintaining adherence to a number of professional principles. These principles include such things as acting with independence and integrity, complying with the duty to the court to act with independence in the interests of justice, acting in the best interests of clients, keeping clients' affairs confidential, and maintaining proper standards of work. I'd hope that all barristers would consider these objectives and principles to be entirely appropriate for an effective regulatory framework. Third, the Act confirms 6 reserved legal activities for which suitable qualification and authorization are required before they can be provided to the public. These reserved activities include the exercise of a right of audience, thus ensuring that the principal skill of a barrister can only be offered to the fee-paying public by those who are appropriately trained and qualified. it is now a criminal offence to perform a reserved activity if not entitled to do so, as well as to pretend to be entitled, or to use any name, title, or description to imply falsely that one is entitled, and specifically to pretend to be a barrister when not so qualified. Fourth, recognising that the professional bodies had historically carried out both representative and regulatory functions, professional self-regulation, the 2007 Act requires that those functions should now be discharged separately, so that representative activities don't prejudice the exercise of independent regulatory functions. It's this requirement that led to the establishment of the Bar Standards Board, the BSB, as the regulatory arm of the Bar Council. Fifth, the Act established three new statutory bodies: the Legal Services Board as a new legal services regulator to provide consistent oversight regulation of frontline regulators such as the BSB. It also created the Office for Legal Complaints and the Legal Ombudsman to handle unresolved consumers' service complaints in respect of all regulated persons, again, subject to oversight by the LSB. And the Legal Services Consumer Panel was established to offer independent consumer advice, or advice on behalf of consumers, to the Legal Services Board. And finally, in line with Sir David Clementi's liberalising intentions, the Act allows the creation of alternative business structures, often referred to as ABSs, through which different types of lawyers and non-lawyers can own, invest in, and manage legal practices. Since the implementation of these provisions, about 1,600 organisations are now established as ABSs. That's roughly 15% of all legal practices. A handful are regulated by the BSB, but most ABSs are licensed by the Solicitors Regulation Authority, and some of them have barristers as members. The Legal Services Act 2007 includes the exercise of a right of audience in its list of reserved legal activities. This covers the right to appear before and address a court, including the right to call and examine witnesses. The BSB is, through the framework of the 2007 Act, one of several approved regulatory bodies that may authorise those who are appropriately qualified to carry on the reserved activity of exercising rights of audience. The Act also contains a number of exemptions. The expectation seems to be that anyone who exercises rights of audience, other than as a litigant in person, will be appropriately qualified. Because unlike some of the other reserved activities, there is no exemption here in respect of someone appearing otherwise than for or in expectation of any fee, gain, or reward. However, judicial discretion will exist to allow a friend to represent a party without payment. And we also have the sometimes vexed issue of Mackenzie friends that can in effect drive a coach and horses through the Act's requirements for legally qualified paid representation. Through this regulatory framework, therefore, barristers are now regulated through delegation from the Bar Council and subject to the oversight of the LSB by the BSB, and are subject to its code of conduct and disciplinary arrangements, all of which are contained in the BSB handbook. Through it, barristers are authorised by a practicing certificate to pursue their professional calling in return for paying an annual practicing certificate fee. In relation to disciplinary matters, the BSB investigates allegations of professional misconduct, and if taken further, then pursues charges before a disciplinary tribunal. These tribunals are appointed and administered by the Bar Tribunal and Adjudication Service, BTAS, on behalf of the Council of the Inns of Court. For its own part, the BSB is looking to modernise its approach to regulation, training and decision making. Some might suggest that it's an open question whether in doing so, it's achieving more targeted, effective, proportionate and cost-effective regulation as required by the 2007 Act, or is succumbing to regulatory creep by straying into areas of professional activity that should perhaps be beyond a regulator's remit. This also brings into sharp relief what I and others have described as the proper role of regulation. With its origins in professional self-regulation, it's perhaps not surprising that all regulation of professionals looks to secure the highest possible standards of competence and performance. This, the argument goes, will ensure that clients and the public receive a high level of competent legal services. However, there is an alternative view, that the proper role of regulation is not to focus on the higher goals of professional interest, but on the minimum necessary intervention in order to protect the public and consumer interests. It is to set the floor below which providers may not go in their provision of legal services. And this should be distinguished from the goal of a profession, and perhaps legal services providers more generally, to aspire to higher or even the highest standards of competence and quality. In short, the floor is entirely a matter for regulation and regulators, while professional aspiration is not. Taking this as an alternative lens through which to view the issue of regulatory independence, there is an inevitable and possibly irreconcilable conflict between the regulatory and representative positions. Under the current structure, the professional bodies and their members see supervision of standards being taken away from them, with a loss of control and decline in professional status following from that. Conversely, the regulators see a group of self-interested professionals seeking to retain or regain control so that they can continue to require standards that are unnecessarily high and expensive in a market for legal services that has insufficient competition and insufficient innovation. And so that brings me to the final part of this lecture, the future. What happens in the future to legal services regulation, and to barristers in particular, is to my mind dependent on three factors. The first is the momentum for further reform, and the second is then to be clear about what is wrong or misconceived in the current framework of the Legal Services Act 2007 that reform could remedy. The third factor is the all-important political will to do anything in response to the pressure for reform. So David Clementi finished his work, on which the 2007 Act is based, in 2004, almost 20 years ago. The structure we have, therefore, predates the global financial crisis, which has arguably led to austerity, shortfalls in the funding of legal aid and the wider courts and justice system, and to a rise in litigants in person. It also predates Brexit, COVID, and a use of technology that has become more extensive and pervasive and led to the rise of artificial intelligence in law. The world that existed in 2004 simply doesn't exist in the same way now. And the inherent tensions in the 2007 Act have become increasingly apparent. Almost as soon as the Act was being implemented, pressures for further reform began to emerge. In July 2014, the then Secretary of State for Justice, Chris Grayling, called a ministerial summit of legal services regulators. As a result of this, the regulators were invited to consolidate their collective strategic view of the difficulties they were experiencing under the 2007 Act and related legislation. And they were asked to identify possible legislative options for creating a regulatory framework that would better support an effective, diverse and healthy legal services sector. Cross-regulated discussions then took place, chaired as it happens by me, and the regulators' views were published as the Legislative Options Review and submitted to ministers in July 2015. Then in January 2016, the Competition and Markets Authority, the successor for the OFT, launched a market study into the supply of legal services in England and Wales. Its work took a year and its final report was published in December 2016. The principal conclusion from its review was that the legal services sector is not working well for individual consumers and small businesses, largely because those consumers lack the experience and information they need to understand their needs, to make informed choices, and to engage confidently with providers of legal services. More importantly, perhaps, the CMA also concluded that these issues are likely to increase over time, and in their view, make the current regulatory framework unsustainable in the long run. More so since some aspects of that framework, in the CMA's view, don't meet the better regulation principles either. The CMA also concluded that the majority of issues cannot be addressed by tweaking the current framework, but would be better addressed through legislative and/or structural changes by the government. Accordingly, in parallels with its predecessor, the OFT in 2001, the CMA recommended that government should undertake a review of the current regulatory framework. By the end of 2016, therefore, there would appear to have been a degree of acceptance that something needs to be done, and a degree of political momentum towards doing it. However, during the period of the CMA market study, and before the government was able to respond to the CMA's recommendations, both the Brexit referendum and a general election took place. As a consequence, the political backdrop changed considerably. We've had the Brexit and COVID pause. Not entirely surprisingly, when the government did respond formally to the CMA report in December 2017, it didn't feel able to commit to the fundamental review recommended by the CMA. It did, however, agree that it would continue to reflect on the potential need for such a review. And then, of course, we had another general election in December 2019, immediately followed by the still continuing consequences of COVID-19. In the context of the UK's exit from the European Union, arguably it's even more important that the regulatory framework for legal services is fit for the future. The democratic intention that is central to taking back control presumes full confidence in our domestic rule of law and legal institutions, as well as maintaining our performance and competitive position in the global economy. The Russian invasion of Ukraine has further emphasised how important to all of us is a meaningful commitment to the rule of law and the independent administration of justice. Without strong, independent legal representation and judicial decision-making, this commitment is more likely to be meaningless. All this in turn requires that the supporting regulatory structure for legal services should be as robust as it can be to secure appropriately qualified and regulated advice and representation. But this must be in question, given the CMA's conclusion that the current regulatory framework is unlikely to be sustainable in the future. It seemed to me in 2018 that the expected government hiatus in regulatory reform would be exactly the right time for some serious thinking to be undertaken. When reform comes, we wouldn't wish it to be rushed or ill-considered. On that basis, I agreed in July 2018 to undertake an independent review of legal services regulation. The final report was submitted to the Lord Chancellor 2 years later, in June 2020, containing both short-term and long-term recommendations for reform, with a follow-up supplementary report on consumer harm in April 2022. In December 2020, the CMA undertook a follow-up review of their market study 4 years earlier, and they concluded that the pressure for reform was still present and expressed broad support for the recommendations in my report. So let me now articulate the principal shortcomings or flaws, as I see them, in the Legal Services Act 2007 and as identified in my final report. I think there are 6 principal shortcomings. There are many more, but these are I think the principal ones. The first is, as I've already indicated, the Act is a large one. Part of the reason for this is that many in the legal professions were concerned at the time the bill was making its way through Parliament. And indeed, they were often supported by the many lawyers who inhabit the Palace of Westminster, that those who would then be responsible for the implementation of a reformed structure wouldn't recognise the importance of a shift away from self-regulation and believed that this could provide too much discretion and latitude to a new style of regulator and one that would involve lay people. They might not understand well enough the particular value and circumstances of legal practice. Consequently, much prescriptive and protective detail was hardwired into the Act. And that's now left us with a rather inflexible statutory structure that often requires overstretched parliamentary or ministerial time and attention to use, let alone to change. Secondly, as I referred to earlier, the Act contains regulatory objectives and principles to which few lawyers would take exception. But it also contains other regulatory objectives that are more challenging. So, for example, the objective to protect and promote the public interest doesn't always sit easily with another to protect and promote the interests of consumers, or with yet another to promote competition in the provision of legal services. There are also objectives to improve access to justice and to increase public understanding of citizens' legal rights and duties. I'm certainly not suggesting that these are not good things to do or laudable objectives, But given the complexity of the underlying issues here, and their interdependency with so many other social and political factors, one might question whether these are entirely appropriate outcomes to impose on regulators. The 8 regulatory objectives are also presented with no indication of an overarching purpose or of hierarchy among them, which then provides insufficient guidance to regulators seeking to balance competing aims. I've already referred to the reserved legal activities. There are 6, and they form the pivot around which the whole Act revolves. So the regulators are approved in relation to one or more of the reserved activities. Those approved regulators then authorize individuals to practice one or more of those activities. An alternative business structure can only be licensed by a regulator in respect of a reserved activity. Each licensed ABS must then have an approved head of legal practice, who must also be personally authorized as a practitioner in respect of at least one of the reserved activities for which the ABS is licensed. And although the legal ombudsman can consider complaints about poor service in relation to any legal activity undertaken by a practitioner, the ombudsman can only do that if the practitioner is authorized for one or more of the reserved activities in the first place. So the reserved activities are like the thread that runs through this whole stick of rock. And while this might all appear at first blush to present a reasonable and even robust approach to regulation, the problem is that the 6 reserved activities are in fact largely an accident of history or the result of political bargaining. There is no modern risk-based foundation for what is reserved or not reserved. I would agree entirely that the exercise of a right of audience and conducting litigation are 2 public interest legal activities that are properly reserved only to those who are suitably trained and qualified. However, also included are notarial activities, which none of the mainstream legal regulators are able to authorize, and the administration of oaths, which, although a reserved legal activity, barely features, if it features at all, in the training program for court of the bar or for any other legal profession for that matter. The remaining 2 reserved activities are often referred to as the conveyancing and probate reservations. However, it's not conveyancing and the administration of estates that are reserved, but, respectively, preparation of the instrument of transfer or charge of property and preparing papers on which to found or oppose a grant of probate or letters of administration. So these 2 are thus incredibly narrow reservations and don't in themselves address the main risk for consumers in these circumstances, which is the potentially large amounts of money and assets involved in property purchase or the administration of a deceased's assets and liabilities. Back to the principal problems. The 4th is that the Act requires those who wish to carry on reserved activities for members of the public must first be authorized by an appropriate regulator. The Act was a product of its time, and the principal route to authorization is through the award of one of the professional titles, such as barrister or solicitor. In practice, the award of the title barrister or solicitor usually carries automatic authorization for 4 or 5 of the 6 reserved activities. That is all save litigation and notarial activities for barristers and everything but notarial activities for solicitors. Indeed, the issue of an ABS license which could be more risk-based, also proceeds on that blanket authorization basis, everything bar notarial activities. Now, while this might appear to be a benefit, given the complexities of modern legal practice, it's hardly risk-based. I've often spoken to litigators who would regard themselves as a liability if engaging in conveyancing transactions or applications for probate. I've talked to many corporate transactional lawyers who freely acknowledge that they would be well out of their depth in, say, clinical negligence litigation. And yet, they are authorized to conduct those reserved activities, however long ago they qualified, or whatever their practice circumstances have been in the meantime. On top of this, there is, of course, the prospect of different title-based regulators having authority to regulate the same reserved legal activity. For example, both the BSB and the Solicitors Regulation Authority, the solicitors with rights of audience in the superior courts, will be prescribing different routes to authorization and applying different codes of conduct and discipline to advocates potentially appearing in the same courts and perhaps even in the same cases. Solicitors and licensed conveyancers could be on different sides of the same house purchase, but subject to different authorization, conduct, and discipline regimes. What's a consumer to make of this potential for overlap, duplication, and inconsistency? And in new multidisciplinary businesses, where practitioners from different professional backgrounds come together in the same business entity, which regulator's approach should prevail? We already have barristers in firms regulated by the Solicitors Regulation Authority. So are we comfortable, as now, that where there is a conflict, the entity regulator's rules take precedence? But there is perhaps an even greater sting in the tail of authorization through professional title. Once an individual is authorized as a barrister or solicitor, or even just one of the reserved activities, their regulator will then assume jurisdiction over all of the activities carried out by that person, whether reserved or not reserved, even though Parliament has determined that only reserved activities must have regulatory attention. A barrister and solicitor are therefore forced to bear the burden and cost of all their professional activities being subject to regulation, where Parliament has not judged the inherent risks of all of those activities to require it. Fifth, the distinction between the reserved and other non-reserved legal activities, combined with authorization and regulation flowing from a professional title, creates a regulatory gap, or in other words, an unlevel playing field that potentially disadvantages qualified lawyers. Once title is awarded and an individual is in practice with a valid practicing certificate, then, as I've just said, all of that practitioner's activities are subject to regulation, even if he or she only practices in non-reserved areas. On the other hand, because non-reserved legal activities don't require authorization, someone who is not legally qualified, has no professional title, can legitimately offer those services to the public for payment without being subject to regulation, other than the general law and normal consumer protections. The preparation of wills is often cited as the example here. A barrister or solicitor advising on a will would be regulated with the attendant burden and cost, but also, of course, with the consequent protection and redress available to a dissatisfied or harmed client. The advisor who is not legally qualified doesn't need to demonstrate any training or certification, doesn't need to carry any indemnity insurance, doesn't need to offer any prospect of redress should things not go to plan, which of course, in the case of a will, might not be until many years later, when the client is dead and can no longer complain. Does it not seem a faintly absurd structure under which the unqualified are not subject to regulation, indeed cannot be regulated by a frontline regulator even if they wanted to be, whereas those who are qualified cannot escape regulation even though Parliament doesn't mandate it, and they ought to be better placed to provide competent advice. And the final significant flaw in the 2007 Act is that although it requires the functional separation of regulatory and representative activities, it does not require the structural, financial, or material separation of the respective bodies carrying them out. So, for example, the BSB shares premises with the Bar Council. It uses many of the same resources, such as technology. It also has to bid for funding from the Bar Council to cover its regulatory activities, even though that money is actually collected directly from barristers by the BSB through practicing certificate fees. The separation and independence between regulatory and representative activities is far from complete. And it gives rise to some tension between the BSB and the Bar Council, as well as to perceptions from those outside the system that there is at least a prospect of the capture of the regulator by those whom it regulates. In short, then, there are some significant shortcomings in the present structure. Inflexibility, competing and inappropriate regulatory objectives, a pivotal set of reserved activities that are anachronistic and don't necessarily include all activities that ought to be regulated, title-based authorization that results in additional burden and cost in relation to some activities being regulated that don't need to be, a regulatory gap that exposes consumers to potential harm and puts qualified practitioners at a competitive disadvantage, and incomplete separation of regulation and representation. So, what next? As a consequence of the various initiatives that I've described, we can now, with a degree of confidence, identify the issues that any review and discussion about the future of legal services regulation will need to address. The agenda for serious consideration has already been set by a combination of the Legislative Options Review, the CMA Market Study and Follow-up, and my final and supplementary reports. When reform does take place, perhaps of most interest to barristers will be whether regulation should primarily be focused on one or more, or both, of legal activities, or the providers who carry them out, whether individuals, professions, or organisations. And perhaps of particular relevance is the future role and regulation of the professional title. In this context, it's worth noting that in its 2016 market study, the CMA said that for the longer term, we consider that in a more competitive legal sector, with appropriately scoped risk-based regulation, title might cease to be subject to statutory regulation. Instead, relevant professions could be responsible for the title. That approach was also endorsed again in the CMA follow-up report in 2020 and in my final report. However, all of the issues for the future are not necessarily straightforward matters with an obvious solution. all regulation is a balancing act of competing interests. Even so, the outcome will affect all current and future practicing lawyers, both in respect of what it takes to become and to remain a practitioner, and how much it costs to do so. Regulation, then, is not just a modern phenomenon, nor, even though we have a relatively inflexible statutory framework for current regulation, is it simply a static product of a prior moment. Formal regulation needs to evolve to reflect changed circumstances and expectations. When the weight of those circumstances and expectations becomes too great for the formal framework to bear, pressure arises for reform. In my view, we are at that point now. However, in closing, I also wish to emphasize that formal statutory regulation is not the only way of regulating the behavior and performance of barristers. In many ways, informal influences are more powerful. There is a strong sense of professional and collegiate identity and obligation built into the very notion of what it means to be a member of the bar. We can call these influences norms or even peer pressure. But whatever we call them, we should not underestimate their power. And we should be careful to ensure that formal regulation doesn't undermine or displace them. Because no formal system can ever be flexible or pervasive enough to influence professional behavior at the moments when the right response matters most. Thank you.
Great. I think we had a question in the Q&A here. If you
let me just find it.
I can read it out. Is there any scope at all for conscientious objection to the cab rank rule for barristers?
That's a very interesting question. There's probably a technical answer, which is it's part of the professional rules. So no, they don't allow for conscientious objection. There's a practical answer, which is if you actually look at the circumstances in which you can refuse, in effect, to abide by the cab rank rule, there is probably scope for not having to abide by it in particular circumstances. But it's a particularly thorny issue, and of course the cab rank rule doesn't apply to solicitor advocates with higher rights, and therefore again, does that put barristers at a professional disadvantage? It's an issue that I know that the BSB and the Bar Council are very alive to, and I think you might expect to see some developments over time, but in what particular ways they might develop, I'm afraid I couldn't possibly say at the moment.
There is another one that's come into the Q&A, Stephen, if you could access that.
Yep. Has the proliferation of ABS diluted the quality of legal practice in some areas? Again, very interesting question. If you look at the makeup of the 1600 ABSs that I referred to earlier, and I'm going to generalize, in very broad terms, half of them, about 800, were previously existing law firms. And so they became ABSs because it allowed them the opportunity to bring into partnership professional managers, or even in some cases spouses, partners, and family members. And so you wouldn't expect there to be any substantive change in the nature of that practice. For the rest, they were somewhat new entrants and sometimes entirely new entrants. And the areas of practice that attracted most new entrants were what we might describe as the volume practices. So personal injury, particularly conveyancing in some cases, will writing and so on. I don't think there's any evidence that ABSs have diluted the quality of service provision. In fact, there is some evidence that ABSs are much more inclined to use technology and be innovative and have a lower rate of complaints than do traditional law firm practices. So no, I think the fear that existed at the time ABSs were first mooted has not materialized, and quality market hasn't, because of things, sure, but not because of ABSs. What is your opinion in future? We will have self-regulation or more likely third-party independent regulation, and which one is best from a practical point of view? Well, we have in all senses really lost self-regulation. The Bar Council, although it's still named in the Act as the approved regulator, has to give its regulatory authority to the Bar Standards Board, and it has done that. And if anything, that delegation will get cleaner rather than amount to some reversion of self-regulation. And therefore, I think we are pretty well in the world of third-party independent regulation, because the Bar Standards Board is not made up of barristers. It is a mix of barristers and lay people. But there is another element to this that I alluded to in the lecture. If you regard the role of regulation, so the role of the third-party independent regulator, to be regulating the floor below which anyone must not go, that is a more limited form of regulation than we have at the moment. And if, as the CMA suggests, and I agree, professional title were to revert to the professional bodies, then that might beef up the role of the Bar Council and the Inns in maintaining a level of competence and quality of barrister members that is above the regulatory floor set by the third-party independent regulator. So in that sense, you could say there could well be a form of self-regulation. It wouldn't be called that, but it would be a form of, it's a form of soft regulation, if you like, aimed at maintaining professional standards rather than complying with the bare minimum that the formal regulator requires to protect the public and consumers, which is best from a practical point of view. Personally, I think the split would be best. Reduce the cost of formal regulation by limiting the role of the formal regulator to the minimum necessary intervention. The cost of aspirant self-regulation, as I might call it, would then be a matter for individuals who wanted to subscribe to those higher standards. And I personally think that choice is best, and reducing the formal mandatory cost of regulation ought to be the way to go. As an RFL, so registered foreign lawyer, are you allowed to do reserved legal activities under supervision? I confess I'd have to check the detail on that, but I think the answer is yes. And in fact, as an RFL, you might even be authorized to do it under your own steam. But I say that is something I'd have to check. It's a point of detail I don't come across very often. And then, how do we decrease the regulatory gap? So if this is a situation where the unregulated, who are not legally qualified, can provide non-reserved activities to the public for payment, how can you decrease that gap? There are two ways, I think, two principal ways anyway. The first is that you could increase the number and nature of the reserved activities. And in that way, you would be constraining the provision of reserved activities to those who are legally qualified and regulated as such. Personally, I'm not in favor of doing that. partly because the process for increasing reserved activities is cumbersome. It would take a long time, and it would add to the inflexibility in the current system. There's also little evidence that the regulated and qualified legal professions are actually willing to close the gap, because many of the services that take place within the gap are of what we might call low value legal services. They don't provide high fees, they don't give rise to high returns and profitability. And you might say, looking at the current argument about defence criminal legal aid work, that in a way that would just be an extension of very poorly paid work for professional people. So for me, I think the way to reduce the regulatory gap is to increase the scope of regulation. And that would mean recognizing that there are people providing legal services who don't really need to have the full professional title. They and their clients don't need the full panoply of qualification and regulatory protection, because most of what's being done is low risk. We've got a situation at the moment where sometimes the client's choice isn't between a lawyer and a non-lawyer. It is between some legal advice and no legal advice. And that increase in unmet legal need, to me, is it's a stain on society generally, but arguably it's also a stain on the profession, because there are legal needs that legal professions are not rising to meet. I would therefore extend the scope of regulation and allow those who are not legally qualified to formally enter the regulated market, but at a lower level. They would have to bear some legal cost, some cost of being regulated within that sector. But many of them are self-regulating, voluntarily regulated at the moment anyway. And a lot of the evidence suggests that the cost to them of formal but low-level regulation wouldn't be any higher than they're currently bearing on a voluntary self-regulation basis. The advantage would be that their clients would have a formal and protected route to redress if something went wrong with the provision by those currently unregulated providers. So it's a complex issue. Ultimately, I think it's a political decision, because it does mean in some way extending the scope of regulation, or equally a political decision to add to the number of reserved legal activities. But as I say, I think extending reservation is the most cumbersome and expensive way to go. Increasing scope would be the most practical and cost-effective way to go. This is a longer question. So what thoughts do I have on any implications that may arise on the broader review of these issues for the implementation of the ETO framework? Provision of pupillage is a bottleneck for the entrance of many into the profession, no doubt including many of the audience here, and so the future of the ETO framework would seem to be of importance. There is an issue with any form of, forgive me for using this blanket word, but any form of apprenticeship, and whether we call it articles or training contract or pupillage, what we're talking about is creating a funnel that allows people to go through an extension, if you like, of the training regime. There is an issue, I think, that will arise for the ETO framework, but my view is that it's not what I would regard as a regulatory issue. There may well be regulations around pupillage, but I don't think the structure of regulation itself should have much of a direct bearing on pupillage. If there is a blockage, then as we've seen with the solicitor's profession, an opening up of the methods through which practical experience and supervision can be achieved might offer some opportunities. But again, there is a cost to pupillage, and there's no doubt that when the regulators said that pupils must be paid, the number of pupillages declined. So again, there's a reflexive relationship here between some elements of regulation, hard or soft, and the cost to the market of that provision. And that is more acute for barristers because, of course, there isn't an entity or a client base that's used to picking up the cost of training. So again, it's a very interesting question. I'm not sure I've given it the considered answer it deserves. But yes, there is some relationship, but I don't think the regulatory framework itself should unduly influence ETO. Right, the legal profession is over-regulated at the moment and burdensome for sole practitioners and small firms. What will be done in future to ease this and make it more practical? I wish I could tell you that I have the magic wand to that one. It should be apparent from the lecture that I agree that the legal profession is over-regulated, in the sense that non-reserved activities are not included in Parliament's view of what ought to be regulated and what must be regulated, and therefore barristers and solicitors and any other regulated person in the market at the moment is being regulated for non-reserved activities, and there is a cost to that. I think part of the difficulty there is that typically the approach of a regulator to regulation, whether it's of reserved activities or of non-reserved activities, is to do the same thing. So it's to require training, to require qualification, to require authorization or accreditation, to require supervision, to require CPD. And all of these things add to the burden and cost of regulation. I would hope that with a more risk-based approach, the regulators can distinguish much more than they do now between what is a reserved activity or a high-risk activity and needs to be properly regulated and supervised, and those that carry less risk and therefore less risk to the client or consumer that don't need to be so heavily regulated, and then do something to shift that balance. That would have some effect on the burden and the cost, particularly for sole practitioners and small law firms. But we need to see something more of a shift towards risk-based. I think we're in the foothills of that. There is actually a lot more that the current frontline regulators like the SRA and the BSB could do now to distinguish between higher risk activities and lower risk activities and the burden and cost that goes with it. I'd like to see them use those powers. It might, however, require some more formal intervention, like a new framework or something from government that says regulators, you've got to move down this path. But clearly, sole practitioners and small law firms particularly are disproportionately affected by the burden and cost of regulation that is itself disproportionate. Looks as though we've either exhausted them from questions or they are exhausted by heat. Okay, done that one. Right, what may be the impact of the use of artificial intelligence on the future of the legal profession? Will that cause unemployment in legal sectors? I think there's been quite a bit of scaremongering about artificial intelligence and what it will do to legal practice. I think the good news for barristers is that it will not replace the need for high quality advocacy on 2 feet or appearing virtually in those matters where there is something serious at stake, whether that's because of the value or the importance or the level of court in which the advocacy takes place. So I don't think we need to fear artificial intelligence. I do think there are many aspects of what I would call consumer legal practice, which is mainly carried out by law firms rather than barristers, where processes and technology could certainly introduce more efficiency and cost effectiveness into their provision of legal services. That might cause some unemployment for people, well, particularly perhaps for lawyers who are too highly qualified for some elements of that service. But the counter argument then is that if we could address the currently unregulated market and the currently unmet legal needs of society, which are vast and increasing, there might well be more jobs for lawyers. And through the use of process and technology, we could free up those lawyers to do what they're really good at, which is the law rather than process. So I think it'll be a mixed picture of employment and unemployment, and it will affect lawyers and non-lawyers in legal practice differently. I think the next question was, Brexit a good political decision? My answer, I think, is that it was an electoral decision driven by politics, and I would prefer not to comment on whether or not it was a good thing. Students appearing by way of the bar transfer test will be able to complete our pupillage by practicing in our country. That's a matter of detail on the bar transfer test that I think the BSB would be much better at answering than I am, I'm afraid. What's the Commonwealth requirement if one has to challenge a decision of the Supreme Court of a Commonwealth country in the Privy Council? Is it possible or beyond jurisdiction? That's a question of international law and jurisdiction rather than regulation. So I think, rather like the Brexit question, I'll thank you for the question and as politely as I can decline to answer it. Do I think the current days of action will have an impact on future regulation? That's a very good question. They could, I think, is my answer. I'm going to confess that I hadn't really thought about the link between these days of action and future regulation. There is I think the real question here is the supply of criminal defence lawyers, barristers and solicitors, into the system in a current framework that doesn't pay them well enough to become or to remain part of the system. I should probably declare at this point I was a member of Christopher Bellamy's independent review of criminal legal aid last year, and I absolutely subscribe to the conclusions that he came to about the level of legal aid funding and legal aid rewards for both sides of the profession. Something needs to happen clearly and quickly to address that. How that might pan out in terms of future regulation, what may happen, as so often happens with government these days, is that if more money flows into the system, then either government directly or the legal aid agency might impose further requirements on the provision of publicly funded legal aid, and that might find a way into future regulation. There may also, long shot, may also be a question here of the supply of enough people into particularly criminal legal aid in the future. And if there aren't enough barristers and solicitors, then the government, again, might be forced to think about increasing the scope of regulation to bring within formal regulation those who could play a role in criminal legal aid, but not necessarily at the level of a fully qualified and competent solicitor or barrister. So we might see more differentiation, I suppose, in the nature of the work being undertaken in criminal legal aid particularly. And I think there have been some early moves on Silex advocates as well, that might reflect the early days of that sort of approach. Again, great question. I wish I'd thought about it more deeply.
Maybe we're done.
Or done in. Well, I mean, thank you for a great set of questions, and more particularly for staying with it for an hour and 20 minutes in current conditions.
Yeah, we'd just like to say thank you for your time, Stephen, from everyone here and from the chat and the inn. Thank you as always. And I'll stay on for 5 minutes or so if anyone wants to ask me some general questions.
Thank you very much, Alice. Thanks, everyone. Bye.
Thank you all for coming. I'm going to close the room now, and I repeat, what I'll send, It was education@lincolnsinn.org.uk. I'm sure you've used it before if you need to ask any further questions. All right, thank you. Goodbye.